Morning, everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today, I am going to let you know whether or not I've determined probable cause, and then we will be talking about release conditions. Today is not your trial date, and so I encourage you not to talk about your case on the record because everything in this courtroom is being recorded. For those of you who are represented by the attorneys from the Public Defender's Office, I do have an attorney, or I have an attorney from the Public Defender's Office, Mr. Brian Reedy, and I also have over at the main jail, Mr. Hector Romero. If you are represented by the Public Defender's Office, then you may speak with those attorneys before speaking on the record. If you have private counsel, they come to the courtroom and they will be able to speak on your behalf. And if you are represented by private counsel who's not in the courtroom, you can let me know and we will see how we can accommodate you. I will be quick to say this morning, though, that if an attorney represented you 5 years ago and you don't have them on permanent retainer, it does not mean that they're representing you today. So please don't tell me that you have private counsel and then we make an attempt to call them for them to come back and tell us we don't represent you, okay? That happens quite often. So just so you know, unless you've retained them for this arrest, they are not representing you on this case. We also have in the courtroom the attorneys from the State Attorney's Office, main attorney, Mr. Eric Linder. We have confinement status in the courtroom. We have pretrial supervision, and we have the clerk of courts. And all these people are here to help facilitate this process. And they can provide some information to the court as far as your attorney making any arguments on your behalf. All right? So I will call each person's name and you will come up to the podium individually and then we'll address you in that order. There are two persons that the jail has asked me to call out of turn, and I will be calling those cases momentarily. But I also want to say to private counsel, depending on where your client is on the docket, they may not be in the room. So if you let us know, especially if they're at the main jail, you can let us know and then we'll call them out and then they'll find them and bring them in. Because of the new changes at the jail, they don't bring everyone in at the same time, all right? Okay, so we have, the jail has asked to call Ricardo Tong Chin. Where's Mr. Tong Chin?
He's approaching, Judge, and my understanding, was it? He has private counsel, Mickey Roque, and I believe Mr. Reedy tried to get in, or spoke to him.
Okay.
Mr. Roque is available to appear by phone right now, Judge.
Okay, it is Thursday.
That's right.
All right, what's Mr. Roque's number?
954
Yes.
854 7554.
Hello, it's Nikki.
Mr. Roque, good morning. This is Judge Jackie Powell, and I'm calling from open court. You are on speakerphone.
Oh, thank you so much, Judge. Hello, how are you today?
I am well, sir. Your client,
Fantastic.
Ricardo Tong Chin, is before the court this morning.
Yes. Yes, thank you. And his wife is waiting for my call, yes.
Okay.
Thank you.
Well, Mr. Tong Chin is before the court for an aggravated assault with a deadly weapon without intent to kill. And I do find probable cause as to that count. So I will hear from the parties as to bond, if you want to go first.
Well, the state, I'd like to see what the state has to say, please.
Your Honor, I'd be requesting a $10,000 bond, no victim contact. I'd also be requesting pretrial release supervision with a GPS monitor. I am concerned about the level of violence that Mr. Tongchin threatened and swung a machete at the victim. I'm also requesting the GPS because it appears that the two parties live next door to each other, literally.
Mr. Roquefort, did you hear that?
I did, but Judge, I haven't had the opportunity to read the probable cause affidavit. And is the probable cause affidavit supported or corroborated by other independent witnesses, or is it just one person's account, and was that account a delayed filing and reporting? And does the state have any prior record to request such a high bond and for a GPS on this case?
Oh, Mr. Roque, I think in facilitating you by calling you on the phone, was at your request, it would be the reason why you have not seen the probable cause affidavit, and I don't believe that it's the court's responsibility to tell you, give you all that information. So if you wish to come to the
But I'm
courtroom.
just saying, Judge, if the state's case isn't so strong and it's not corroborated by other evidence, and it's just an allegation and there's no physical evidence to support it as well, then I question the strength of the state's case. So I was going to be asking for a bond of a standard bond, which would be $2,500, $2,500 on an ag assault on something like that.
Okay. Does Mr. Tongchin have any priors?
No, Your Honor.
Okay.
See, that's exactly why I was saying it, Judge. So I didn't understand for such a high bond and for a GPS in addition to it, when it's an aggravated assault, there may be no merit to the case.
All right, it looks like you'll have your time in court in your division. The allegations in this case is that Mr. Tongchin approached his neighbor with a machete, swung it at him more than once, and that, there is a reason behind this incident. And so based on the allegations, the court does find probable cause, and I will impose a $7,500 bond, no victim contact, and Mr. Tongchin is also the immediate neighbor of the alleged victim, and so I will also add a level 2 GPS to his release. Okay? All right.
Understood.
Okay, sir. Have a good day.
Have a great day. Bye-bye.
All right, bye. Okay, the next person to be called out of turn, Ernst Giles on page 26.
Our Creole interpreter is present, Your Honor.
Okay.
The Creole interpreter is there, so listen.
Ma'am, please raise your right hand. Do you swear or affirm to translate from Creole to English and English to Creole?
I do, Vivian Saint-Ange.
Good morning, Ms. St. Ange. Mr. Giles,
Monsieur Gilles,
you are before the court today
ou devant tribunal là,
on count 1,
sous accusation 1,
battery on an officer,
côté bâton police,
and count 2
2, accusation 2,
is petty theft.
c'est côté fait anti-vol.
The court does find probable cause,
Un tribunal là joue une cause probable,
and I will hear from the parties in regards to setting your bond.
m'a pral koute avocat yo pour dire qui caution probable.
Your Honor, I'd be requesting a $1,500 bond on count 1.
M'a demandé 1,500 pour accusation 1,
Judge, at this time, nothing to add from the defense.
un juge pour le moment pas gen rien pour me dire.
Okay, the court imposes a $1,500 bond.
OK, tribunal a mette $1,500 comme caution.
Okay, sir.
OK, monsieur.
Judge, I'm just going to be requesting a property order so we can access this property.
M'a demandé pour pas mettre l'ordre pour le cas et joindre affaire li.
I will sign that order.
OK, m'a signé.
All right, thank you. And just before the Creole interpreter leaves, is there anyone else who will need the Creole interpreter? Madam Interpreter? Ms. Sage?
Gen lot moun ki bezwen interprète créole?
Part of the, right? Yeah, I got it right. No, Judge.
All right, thank you.
Why you, but you're laughing. That's how you say it. That's not how you say it?
Okay,
Okay.
on page 1, we have Luddy Tundru Delmont, page 1.
She's approaching, Judge, and she has her private attorney.
Yes,
Good morning, Your Honor.
good morning.
Sue Ann Robinson on behalf of Ms. Letty. We're asking for the bond to be set at $2,500. I did have an opportunity to speak with the state, who's asking for a $10,000 bond. The defendant is 19. She has no priors, and she's the sole breadwinner in the household. So we're just asking for a standard bond so that she can return to work. And during the course of the state's investigation into filing the matters, she is going to reside with her sister.
Okay,
Yes, Your Honor, I spoke with counsel. Unfortunately, we couldn't reach an agreement. I am going to be, and she does not have a record. I am going to be requesting a $10,000 bond and no victim contact. This is based on the level of violence that she allegedly stabbed the victim in his stomach, which required him to be brought to North Broward Hospital for emergency surgery.
So the individual from the probable cause affidavit is her her boyfriend, and she also lives with the boyfriend's mom. So that's why we indicated she could live at her sister's house during the course of the state's investigation into the matter. But again, she's 19 and she's the only one that's working.
all right, the court finding probable cause, I am going to impose a $5,000 bond on count 1 and no victim contact until further order of the court.
Okay, and the she'll be allowed to go to the residence just to collect her personal belongings with BSO.
It'll be one time with the BSO, correct?
Thank you, Your Honor.
All right.
And Your Honor, our Spanish interpreter is present.
Spanish interpreter is here for whom?
Miss Simon on page 1, Judge.
Oh, then she's next. Eudice Simon.
Señora Eudice Simon.
Ms. Simon, you are before the court today.
Señora Simon, usted se ha comparecido en la corte hoy
Aggravated assault with a deadly weapon,
acusada de agresión con un arma mortífera,
burglary, unoccupied structure, unarmed,
entrada ilegal en un negocio pero sin arma.
and count 3 is touch or strike battery.
El tercer cargo es tocar o golpear, agresión.
The court does find probable cause.
La corte decide que existe motivo
Did she
fundado.
get in, or is it attempted burglary?
¿Logró
She got
entrar
in,
o es
right?
solo intento de entrada ilegal?
The allegations are she entered.
She did.
It does appear as a dwelling, though, rather than, I know it says structure.
Okay.
Se alega que la señora sí logró entrar y vemos ahora que fue una casa, no era un negocio como habíamos indicado anteriormente.
Okay.
Your Honor, based on she has no record, based on the totality of the circumstances,
La señora no tiene antecedentes, pero basado en la totalidad del incidente,
I'd be requesting a $5,000 bond on 1,
vamos a pedir una fianza de $5,000 para el primer cargo,
a $5,000 bond on 2,
$5,000 de fianza para el segundo cargo
and a $2,500 bond on 3,
y $2,500 de fianza para el tercer cargo.
and obviously in order of no victim contact, please.
Obvio que se va a pedir que se le prohíba tener contacto con la supuesta víctima.
Nothing further, Judge.
Nada más del Estado.
Judge, unfortunately, $12,500 is something that Ms. Simon's not going to be able to afford.
De parte de la defensa, desafortunadamente, señoría, la señora no va a poder pagar $12,500 de fianza.
Now she lives separate and apart from the alleged victim.
Ella no vive en el mismo lugar donde vive la supuesta víctima.
She lives in Oakland Park.
El señor vive en Oakland Park.
She's a stay-at-home mother.
La señora es una madre soltera. Es una madre que está sola en su casa con sus niños.
She has a 6-year-old child, Judge.
Tiene una criatura de 6 años.
Now she's going to be reaching out to her friends and family to help post her monetary bond.
Se va a comunicar con amistades y con los parientes para tratar de pagar esta fianza.
Specifically, one person that she's going to be reaching out to, she advised me that he works at a restaurant.
Una de las personas con las cuales se va a comunicar me dejó saber que esa persona trabaja en un restaurante.
So I'm going to be requesting a $2,000 bond on count 1.
Por eso vamos a pedir que la fianza del primer cargo sea de $2,000,
$2,000 on 2 and $1,000 on 3.
$2,000 para el segundo cargo y $1,000 para el tercer cargo.
So defense is asking for a total of $5,000 on Ms. Simon's behalf for a person who's never been in trouble with the criminal justice system. She's been living here and has strong ties to community.
Por eso la defensa va a pedir una fianza total de $5,000 y esto es viendo que la señora no tiene ningún tipo de antecedente, no tiene ningún tipo de vínculo con el sistema penal anterior y también vive aquí por mucho tiempo y tiene muchos vínculos en la comunidad.
Based on the allegations that are before the court today,
Basado en las alegaciones que se han presentado en la corte,
the allegations which are
y las alegaciones son
that Ms. Simon assaulted someone using a knife,
es que la señora Simon supuestamente agredió a una persona y utilizó un cuchillo
and then broke into that person's home
y después entró ilegalmente a la casa de esa persona,
through a bedroom window,
entró por la ventana de un dormitorio
and then broke items while in the home.
y también rompió pertenencias que estaban en esa casa.
The court does find probable cause for all counts,
La corte decide que existe motivo fundado para cada uno de estos cargos
and further, the court
y además la corte
finds that a reasonable bond
decide que una fianza razonable
in this matter,
para este incidente,
counts 1 and 2,
el cargo 1 y 2,
the court is going to impose a $3,000 bond on each count.
la corte le va a pedir que pague una fianza de $3,000 para cada cargo
And then on count 3,
y para el tercer cargo,
the court is imposing $1,500 bond.
la corte pide una fianza de $1,500.
No victim contact
Le queda prohibido tener contacto con la víctima
and no return to this location.
y le queda prohibido regresar a ese lugar.
Okay, good luck, ma'am.
Y buena suerte, señora.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite la ayuda de la intérprete? There's
Judge,
somebody,
no one else here at Maine. I don't know if the other facilities.
I don't know if somebody raised their hand.
Wait, someone just raised their hand. Sorry. Get to know?
¿Alguien que necesita la intérprete?
Yes. Velez Garcia, Judge. What page? Okay. Judge, Ms. Valdez Garcia, and she declined the services of public defender.
La señora Valdés García necesita que le ayude al intérprete. Se ha negado a que la represente el defensor público. El caso está en la página 5.
Ms. Valdez Garcia,
Señora Valdés García,
you are before the court
él comparece.
for count 1 is a felony capias.
El cargo número 1 es orden de arresto, es una acusación de delito grave.
The charge is grand theft.
Y el cargo que tiene ese delito es hurto de grado mayor.
And there is a no bond hold
Usted tiene una retención sin posibilidad de fianza.
and not for magistrate.
Y no es algo que puede decidir la jueza de primera instancia.
On count 2,
Para el segundo cargo,
it's a misdemeanor capias,
es una orden de arresto por un delito menor.
and the charge is theft,
Ese cargo también es hurto.
and that has a $500 bond attached to it.
La fianza de ese cargo es $500.
You have court tomorrow
Usted va a tener otra cita en la corte mañana.
in your felony division
Eso va a ser en la división de delitos graves.
at 8:30 a.m.
Va a ser a las 8:30 de la mañana.
Okay?
¿Ok?
Good luck, ma'am.
Buena suerte, señora.
Okay? Is there anyone else who needs the Spanish interpreter?
¿Alguien más que necesite la ayuda del intérprete?
No one is raising their hand, Judge.
At North Broward or Conti? Paul Ryan?
No, ma'am.
All right. Thank you very much.
Thank you, Your Honor. Have a great day.
You too. Have a good day.
Judge, on Miss Simon, I forgot to ask for a photo order.
I'll sign that order.
Thank you. Mr. Reedy, did you get on Miss Simon?
I got you.
Thank you, Mr. Reedy.
Okay, then, do we have David Cadet in the room? He's on page 27. If he's not, he has a private attorney in the courtroom, if we can pull him.
Judge, they're gonna go ahead and get him right now.
All right, when he's in, let me know.
Yes, Judge.
Tasha Marshall,
Miss Marshall, come on up, please.
all right, Ms. Marshall is before the court for aggravated assault with a deadly weapon. It's domestic violence. The court does find probable cause. Like on the radio, you can't have dead time.
Oh, Your Honor, I'm sorry.
Well, we're not on the radio, so.
Oh, no, I'm sorry. I thought you might have been reading something. If
No,
you're
no,
ready for it.
no.
Okay. It's too much in the way blocking.
I know.
Your Honor, I'm going to be seeking a $25,000 bond. Pretrial release of the GPS monitor, no contact. Even though I know it's a standard part of the no contact order, I'd just ask if the court could, in addition to it being placed on the written order, that if the court could order Ms. Marshall to not be in possession of any firearms or weapons. Your Honor, I know the charge is aggravated assault. Frankly, I believe these allegations could support an even more serious charge. I am very concerned about the allegations that she admittedly and intentionally fired a gun into the bathroom that the victim was in through the door, knowing he was in there. Fortunately, he was not struck by the bullet. Ms. Marshall, in 2017 in Orange County, was arrested for 2 counts of violation of injunction for protection against stalking. In full candor, I cannot tell what ended up happening with those charges. It was 2 charges. In the Florida clerk system, it shows that there was a withhold on 1 count, but it also shows on the progress docket that the state null pros the charges in October of 2017. So I can't really advise the court what ended up happening with that case, other than she was arrested on those charges. In 2014 in Orange County, she was arrested for a battery. That charge was also dropped. Nothing further.
Judge, at this time, we're going to be requesting a $5,000 bond on Miss Marshall's behalf. She's 27 years old. She's a stay-at-home mother. She lives locally here in an apartment at Sunrise living separate and apart from the alleged victim. She's right now, my understanding, Judge, is she's been here for approximately 9 months. She's relocated from Orlando. At this time, from what she advises me, she is not working. So I'm going to ask you to take that into consideration to determine reasonable release conditions for Ms. Marshall.
All right, the allegations as presented to the court this morning, and not only do the allegations say that Ms. Marshall fired a gun in the home, there were minor children also in the home at the time. And based on that allegation, the court does find probable cause for aggravated assault with a deadly weapon. There was also a knife that was used. It's not just a gun. First it was a knife, and then there was a gun. And so the court does find that the reasonable bond is $25,000, and that's going to include a level 2 GPS. Ma'am, you shall not possess any firearms or weapons, and no victim contact until further order of the court.
And Judge, Mr. Cadet is here.
Okay, thank you.
Sir, come on up. Your private attorney, Mr. Rydell, is right there. He's on the bottom center TV screen.
Morning, Judge.
Good morning, Mr. Rydell.
Joshua Rydell, Affidavit Cadet. He's present.
Have you had an opportunity to speak to the state?
Judge, the answer is yes, and here's what I'm going to be asking today. I'm actually not contesting probable cause.
Okay.
And I'm asking the court to just impose the standard bonds on the new arrests. However, I am asking the court to set a bond on the violation of probation, and let me indicate why. Judge, Mr. Cadet was arrested, and if you look at the PC in this case, he was arrested on April 24th. Mr. Cadet was arrested on an administrative search through probation. He was taken to jail. He was processed on a violation of probation warrant with a PC. Now, it's unique because the physical violation of probation warrant, as docketed by Odyssey, references that he was arrested, there was a search, and he had drugs on him. They only charged him per se in the warrant with just the felony cannabis, but the PC that was presented to the court listed other drugs. The court did not know that there was going to be new substantive charges coming down that are the exact charges from the administrative search. So Mr. Cadet went to court on the 25th and admitted probation and was reinstated to probation. Then 2 weeks later, the detective, and I find this a little disingenuous and it's important to point out, the detective knew I was his lawyer. I talked to him. I orchestrated his surrender yesterday, but they still questioned him in the PC where he made admissions. Neither here nor there. We plan on admitting the substantive violation. That's not the point. The point is he's now being essentially violated again for what he's already admitted. I went before Judge Coleman earlier this week, explained the situation to him. It was when the detective called me and said, I got to arrest your guy. And I go, okay, well, Judge, and Judge Coleman looks at me and goes, I can't do anything because it's not before me yet. I kind of agree with you. He didn't make a ruling on it. So right now, I don't want my client sitting in jail any more than he needs to. So I'm asking the court to ROR him with the right for the state to revisit. I have no issue with that if we go before Judge Coleman and the state seeks some other remedy, I'm okay with that. But for the purpose of today, he's been there, done that with this allegation, just not with the new arrest for the felony.
Your Honor, I do dispute some of the allegations Mr. Rydell is making. I reviewed the warrant that was signed, and
What was the 948? He went to jail on the
but
948.
there was a warrant. I see that was an affidavit prepared by his probation officer, and all that's contained as the basis for the violations in that affidavit is possession of cannabis. It does not make any mention in the affidavit of amphetamine or cocaine. And that's why, Your Honor, it would appear, and those are the drugs that were obtained after the search warrant was executed, that was received and applied for and received upon the administrative search.
Well, it's not true. I don't want to correct you, Mr. Linder, and I apologize for interrupting, but it's very clear. The PO found all the drugs. Very clear in the narrative. So if you read the PC, he doesn't highlight it as much in the affidavit. It's on his attached PC that he references the drugs. But if you read the PC in the case that's before the court, very clear the PO is the one who found all the drugs.
It mentions, Your Honor, it mentions there was a powdery substance which was thought to potentially be cocaine, and then it mentions all investigators vacated the residence. So the probation officer couldn't know for a fact, and that's why it's not in the affidavit. My point is the other drugs were never in, and he had his VOP hearing in front of Judge Fine. Judge Fine was never asked to consider the other two drugs. So those allegations have never been considered by a judge for his violation of probation. So I don't believe it is the same exact consideration. I'm not saying Judge Coleman's going to necessarily do anything different, but he should be able to make the decision tomorrow because there's allegations that were never considered at the end of April for the prior VOP.
Okay. All right. I didn't tell Mr. Cadet what he was before the court for. Mr. Cadet, count one is possession of amphetamine. Count two is possession of cannabis over 20 grams. Count three is possession with intent to sell, manufacture, or deliver cocaine. Count four is possession of drug paraphernalia. And count five, as you've heard your attorney arguing, is the violation of probation. Here's what the court does find probable cause, and he does have court tomorrow, Mr. Rydell. So I am not going to make any changes on the violation because he'll be before that judge, and I'm sure that all the argument you have, argument that you will present on behalf of your client, I'll leave the standard bonds in place, and then that can be argued further tomorrow before his division judge.
Thank you, Judge.
Okay. All right, Mr. Shate is here. He does have four. Well, is Jacqueline Nebellini here today? She's been a
She
reset.
is a medical reset, Your Honor.
Jacqueline Nebellini. There's some capious matters, all right? And then on page 13, Michael Catania.
Conti, Your Honor.
Thank you. Good morning, Deputy.
Good morning, ma'am. How you doing?
I'm well. Mr. Catania?
Yes, ma'am.
Okay, so, Mr. Catania, you are before the court today because there was an ad charge for a misdemeanor capious and a trespassing charge. But I've been advised that when the capious was issued, that you were already in custody, okay?
Yes, ma'am.
So, but I'm also told that you have other charges that are pending. So do we want to leave this case and let it go to the division?
Division judge.
Okay, all right, and then you'll be able to discuss all the cases, sir, with your attorney, okay?
All right.
All right, good luck, sir. On page 13, Stacy Isom.
She's in the main jail. He's in the main jail, sorry.
Is Mr. Isom in the room?
He is, Judge. He's
Okay. Okay.
Judge, the city of Fort Lauderdale would offer time served.
Okay, Mr. Isom, you are before the court this morning for a municipal ordinance violation for trespassing. Your attorneys has an offer from the city for adjudication and time served. Sir, do you wish to resolve your case with that offer?
Yes, ma'am.
Okay, Mr. Isom, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Isom, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, do you need any more time to speak with your attorney?
No, ma'am.
Sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, you understand that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes.
Yes, ma'am.
Then, Mr. Eisen, what plea do you wish to enter?
Uh,
Guilty or no contest?
no contact.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. Good luck, sir.
Thank you.
And then on page 14, we have Omar Payret.
Mr. Pierre is here at 8, come on up, Mr. Pierre. He's approaching, Judge.
Mr. Perret, you are before the court on some 8 misdemeanor cases, and one of them is a state charge, and then the remaining 7 are municipal ordinance violations.
Judge, the city of Hollywood would prefer that this goes to the division.
Okay, so, all right, and sir, because of the number of charges that is before the court, I find probable cause this morning, and you'll go before your division judge to resolve or to discuss further your charges, okay? All right, good luck, sir.
Thank you, Judge, have a great day.
You too. Tiara Twitty,
Paul Ryan, Your Honor.
okay?
Paul Ryan, Your Honor.
Thank you. Good morning, Ms. Twitty.
Good morning.
Ma'am, you are before the court for a petty theft charge, and the court does find probable cause. It's an ad charge, so,
Yes, Judge. Ms. Twitty has some no bond holds
okay?
with Judge Usan. It appears she has a court date tomorrow, as I advised her earlier.
Okay, so then I'll leave the standard bond in place, ma'am, and you do have court tomorrow before Judge Yusan, is that correct?
Okay.
Okay.
Yes.
All right, good luck, ma'am.
Good luck, Ms. Twitty.
Geralakia Atkins,
Also Paul Ryan.
okay?
Good morning.
Good morning, Ms. Atkins. You are before the court for 2 additional charges, and both are felony violation of probation with no bond holds. And so tomorrow you will be before your division judge at 8:30, okay?
Okay.
All right, good luck. Kiana Dennison,
Ms. Dennison is here, President Manger, she is approaching. Come on up, ma'am.
all right. Ms. Dennison is before the court for robbery with a firearm. And the court does find probable cause. And I'll hear from the parties when they're ready.
Your Honor, I do believe that the proof of guilt is evident or presumption is great in this case. That being said, I'm asking the court to set a $10,000 bond, pretrial release of the GPS monitor, no victim contact from Ms. Dennison. I spoke with Detective Swisher, who authored the probable cause affidavit. She provided me with some mitigating information. But I want to be clear for the court, because her co-arrestee is going to be before the court later in the docket, and I'm just letting the court know now I am intending to seek a no bond on him. I am giving, I do note that she was not the one in possession of the firearm, but I'm also greatly concerned, based on the allegations, that even after the victim was robbed, that the defendant tried to force him to allow them to enter into his home. And fortunately, he was able to enter and lock them out before they were able to.
Okay.
Judge, under the circumstances, normally I would agree with the state that this is a reasonable release condition, but I just spent Ms. Dennison, and she was trying to come up with anyone that had any sort of money, but she can't think of anyone. The only person is her mom, who just started working. She doesn't even think that she can afford even going through a bondsman very much. Judge, we're going to be requesting $1,000 bond plus level 2. She's 20 years old. This is her first arrest. Don't talk. She's a registered voter in our community. She lives in Fort Lauderdale. She started working approximately 4 months ago at a place called Cash America Pawn, where she only makes about $10 an hour. She will be abiding by any court order. She will be returning to court, Judge. She just wants to be able to fight this case from the outside, Judge. But right now, financially, she's saying she can't afford almost anything. So we're asking to take that into consideration, determining reasonable release conditions for Ms. Dennison.
Okay, the allegations before the court this morning are pretty serious, and the court does believe that there is great concern for the community. The allegations indicate that this was a robbery with a firearm, with then forcing the alleged victim to his home, an attempt to get into his home. And so based on those allegations, the court finds that a reasonable bond at this time is $10,000, and that's going to include a level 2 GPS. Ms. Dennison is to have no contact with the alleged victim, nor to return to this location. Okay, Joanne Armbrister.
Ms. Armbrust, come on up, please.
Ms. Armbrister is before the court for intimidation, right, or send or threat to kill or injure, and the court does find probable cause. I'll hear when the parties are ready.
Yes, Your Honor, one moment. Based on and it appears there were multiple threats to kill, Your Honor, and it does appear the parties know one another. I'm going to be requesting a $10,000 bond and no victim contact.
Judge, we're going to be requesting a $2,500 bond on Ms. Armbrister's behalf. My understanding at this time, she was working. Unfortunately, she's on medical leave right now. She's been on medical leave for about 10 months. When she was working, Judge, she was making approximately $12 an hour. She's 47 years old, been living in our community her whole entire life. My understanding, Judge, this is her first arrest. She's a registered voter. She lives locally here in an apartment which she rents, and she lives there by herself. Her monthly rent is about $1,500. From what she informed me earlier today, she didn't have the financial resources to post the rent for this month. So right now, financially, she's in very bad shape. Judge, we're going to be asking for the court to assign a phone order so we can access her phone contacts to see if somebody can post a monetary bond. And we're going to ask you to sign a medical screening order, Judge.
Okay, I will sign those orders. Based on the allegations that's presented to the court, there were several text messages threatening to kill. And the court does find that there is a great concern for the community, and I am going to impose a $10,000 bond. No victim contact. Ma'am, that means no texting, no phone calls, no social media, no emails, no contact. Do you understand that, ma'am?
Yes, ma'am.
All right, good luck. Jeff Davis.
Yep, it doesn't even have.
Please approach you, Judge. Come on up, sir.
This is out of state. Oh, yeah, it's out of state.
Mr. Davis, you are before the court for out-of-state felony hold. It's a no bond hold for the state of Alabama. And so you will be going before the extradition court next, maybe Tuesday or Thursday of next week, so that that issue can be addressed, okay? Eric Brenner.
Mr. Brenner, come on up, please. Please approach you, Judge.
Okay, Mr. Brenner is before the court. Count 1 is touch or strike battery domestic. Count 2 is criminal mischief. Count 3 is disorderly conduct. Count 4 is disorderly intoxication in a public place. Count 5 is a felony capias, which is a no bond hold and not for magistrate. Count 6 is a felony capias, no bond hold, not for magistrate. Count 7 and 8 are violation of pretrial, and those two are, 7 is a no bond hold. On count 8, there is a $100 bond that is attached to it. And also, I have notes that you will be before your division judge tomorrow at 8:30. The court does find probable cause, and I'll hear from the parties.
Your Honor, I've been advised the alleged victim is present and wishes to address the court.
Okay?
Okay,
Just hold on just a minute.
all right.
Okay, good morning, ma'am.
Good morning.
You wish to address the court?
Yes, this is in regards to the charges that were.
Okay,
from
hold
yesterday.
on. What is your name?
My name is Alice Brenner. I'm his wife.
Is Ms. Brenner one of the alleged victims? I don't.
Yeah,
I
she
see.
is the listed victim, Your Honor. The other mentioned parties were witnesses. And I think there's just one other alleged victim as to the criminal mischief.
Okay, ma'am. Please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. And please state your name for the record,
Alice Brenner.
okay? Ms. Brenner, what do you wish to say?
When this happened yesterday, obviously I was there, but no one came to talk to me about what happened, like the police officers. And when I found out what charges were being held against him, I mean, we were celebrating our anniversary yesterday, and we were just trying to leave. Like, I'm here right now just to help as much as I can.
If I may ask Ms. Brenner a few questions, Your Honor? Thank you. Ms. Brenner, did you seek and obtain a injunction order of protection against Mr. Brenner last year?
I did, and
And,
okay, go ahead.
and was it granted and was a permanent injunction put in place ordering Mr. Brenner to not have contact with you? And I would note you did file a motion to dissolve the injunction beginning of this year, correct? And are you aware that Judge Moon signed an order denying that motion?
Yes, but there's like
So you would acknowledge to the court that there's still an injunction in place from a court order that he's not to be within a certain distance of you? Well, I'm just, if you'd answer the question for the court. Are you-
No, yes, everything's correct what you're saying.
I have no further questions, Your Honor, and I am concerned. He wasn't charged with it. I don't even know if the officer realizes, but the court should be aware there is a court order in place that he's not supposed to even have any type of contact with her whatsoever. Judge Moon obviously felt serious enough about it that she denied Ms. Brenner's request to dissolve that injunction. I would also note that there are multiple independent witnesses that advised law enforcement that he did commit the battery throwing objects that struck Ms. Brenner. There was another independent witness that it doesn't appear that he might not have seen him throw the items. He did corroborate a certain amount of information that those witnesses provided to law enforcement. I'm going to be requesting I was going to be requesting a $2,500 bond, but Your Honor, frankly, considering that there's an injunction in place and that he shouldn't have even had any contact with her to begin with, I'm requesting a $7,500 bond and no victim contact.
Yeah, you can go ahead.
Okay, so when I tried to dissolve that, something happened with the courts, and I haven't been able to go back to do it again. But I put in a request to dissolve it, and they're like, wait 15 days. I don't know how long it's supposed to be. So I waited. I called. I waited. Everyone kept telling me, wait. You'll get it in the mail. I finally got the letter in the mail for the court date to dissolve the order, but the date already passed. I missed it, so they denied everything. And ever since then, I didn't have any time to just go back in to do the whole process all over again. And that's why it was denied, because according to the courts, I missed it, but I was never notified until after the court day already passed.
Okay.
Judge, I'm going to be requesting a $1,000 bond on Mr. Brenner. I do realize that counts 5 through 8 are no bond holds. I already spoke to Mr. Brenner about that. So he's going to have to go and see that judge tomorrow. Obviously, Judge, you heard from the victim. She was very candid. She answered the state's questions honestly and basically acknowledged what Mr. Lunder was saying is correct. However, then she went ahead and followed and gave an explanation. From her demeanor, from what I can basically tell, more to this story than what is being portrayed as far as the arrest, Judge. I do not believe she's in fear. I do believe wants contact with Mr. Brenner. My understanding is Mr. Brenner is the sole financial provider of their household. He's an Uber driver. They share, I believe, a 4-year-old child. That's their present, Judge. Judge, I'm going to be asking at this time for a $1,000 bond on count 1.
Your Honor, and I apologize. I just want the court, for the record purposes, I want the court to be aware. Mr. Brenner was also arrested for an assault against Ms. Brenner late last year. That was dropped. And I would also note, according to one of the witnesses, Mr. Brenner threatened Ms. Brenner's life if the police are called.
It does say that in probable cause affidavit, that if you call the police, that's your life. That's the line that's in. Ma'am, I'm not going to listen to anything more. You need to probably get an attorney to help you with whatever is going on. Based on what I've heard this morning, I do find that a reasonable bond on count 1 is going to be $5,000. And there is an injunction that is in place, and until the court says otherwise, it means no contact. You took out this injunction, and so you've got to see through to the end. And if you want it to be withdrawn, you have to follow through with the courts and do what's needed to accomplish that. Okay? And Mr. Brenner does have court tomorrow in his division at 8:30 a.m. St. Fleur Joseph.
That's what I'm saying.
All right, Mr. Joseph is before the court. There's one count of aggravated battery on a pregnant, the victim is pregnant. The court does find probable cause.
We're ready to proceed, Judge.
Okay?
Your Honor, the state is going to be seeking a $15,000 bond, pretrial release with a GPS monitor. I'm greatly concerned, not only for the victim, but the unborn child that she is carrying at this time, based on the allegations, and that not just the allegations of his continuously punching her, but also the allegation that he threw her to the ground and kicked her in the stomach multiple times. I would note Mr. Joseph was arrested in 2017 for domestic violence charges of aggravated assault, a deadly weapon, and battery against a different alleged victim. Those charges were dropped. Nothing further.
Judge, I'm going to be requesting a $7,500 bond on Mr. Joseph's behalf. He is working at Ross. He lives separate and apart from the alleged victim. He lives with his mother in Lauderdale Lakes. She is a caretaker. He's been here his whole entire life. He's 22 years old. Judge, the court, he's going to abide by the court's orders as far as no contact, but he believes if the court were inclined just on around $7,500, that potentially his mom can afford that, Judge. So that's why we're requesting that amount.
All right, the court's imposing a $10,000 bond, no victim contact until further order of the court. Wayden Emery,
Morning, y'all.
good morning.
Mr. Emery.
Getting in at the right time.
Oh, wow. All right, Mr. Emery's before the court for domestic battery by strangulation. The court does find probable cause.
Your Honor, if I may.
Sure.
I just spoke with his son, Kevin.
Okay.
I know Mr. Emery is a neurosurgeon, but he's retired, semi-retired at this time. He was diagnosed with cancer last year. His son had to help him with trying to pay the mortgage. So the strain on his family as well as what's going on in his dad's life, their funds are very limited at this time due to everything that's taking place.
Okay.
I know the victim, who is his wife, I think they're still married. She has her own place in Boca, but I know she just recently moved back in, so I don't know how that will play out if she'll move back, but the son did say he can probably try to find a place to stay until he gets that situated.
Okay.
One moment here. Your Honor, I'm going to be requesting a $10,000 bond, no victim contact. Our office had contact with the alleged victim. She is in fear. She advised there has been violence in the past in their relationship. The information she provided our victim advocate, I believe, is that I don't believe she intends to reside at that home. She does have some property there, so I told the victim advocate to advise her she should go if she wants to get her property, she should go with law enforcement. I just want Mr. Emery to be aware that, at some point, because I imagine the court's going to be ordering no victim contact, depending on when he gets out, she may be coming back to the home just to retrieve her property. Your Honor, I would also note he was arrested or he did have a charge of a domestic violence battery against a different alleged victim in 2012, and that was dropped.
Okay.
Judge, as you heard, he does have a clean record. He's a registered voter. He's 66 years old. He's a physician because of medical issues that he is going through. He's no longer working. He's going through treatments right now where it requires him to travel basically about once a month to Houston to undergo very serious treatment for his condition. Judge does have family. He's grateful that his son reached out already to a bondsman. They do live separate and apart. He's going to have no contact with the alleged victim. So he's basically relying on his son to post his monetary bond. From what my understanding, from what I just heard, his family right now are going through a financial tough time, dealing with a lot of things going on, particularly his medical issues. So I do not know if they'll be able to come up with a bond of $10,000. I'm going to be asking for $5,000 bond, considering this is he has a clean record. He's going to be coming to court. He's not a flight risk. That's what we're requesting for at this time, Judge.
And I just
Okay.
want the court to be aware. I ran a check in the Broward County Property Appraisal's website. And I ran a check in the property that's listed as his address in here. I'm showing a property value over $1 million. A home with over 6,500 square feet.
Judge, as I said, he was very successful in the practice he was doing. He's not working. He was forced to basically close his practice down because the medical issues require him to go to Houston basically once every month for treatment. That's taken a toll on the family, Judge. So there is an explanation.
All right, this time the court is going to impose a $7,500 bond, no victim contact. And just so that Mr. Emery knows that I will allow I don't know her name, the alleged victim to show up one time with law enforcement to pick up her stuff. Okay? Okay, you're welcome. Deandra Williams.
He's coming up. Mr. Williams, come on up, please. Now we're going to find out.
All right, Mr. Williams is before the court. This is on a 24-hour perfection as to count one. I did receive a supplemental report this morning, supporting the allegation of the strangling. That was the issue yesterday. So the court does find probable cause, and I'll hear from the parties as to bond.
Your Honor, I'm going to make a request. I spoke to Deputy Zvolensky. Count 2 should just be a misdemeanor battery.
Okay?
I'm going to be requesting a $7,500 bond on 1, a $2,500 bond on count 2, and no victim contact.
Okay?
Judge, we're going to be requesting a $2,500 bond on count 1, $1,500 bond on count 2, making it a total of $5,000. Right now, Mr. Williams is working as a dishwasher in I believe, city of Windward, called Beacon and Gray. He believes at this time he probably lost that job, but his financial resources are limited. He's going to be counting on his grandmother, who he resides with in Miami, to help him with the monetary bond. My understanding is she's on a fixed income, receives Social Security. He believes that maybe his grandmother, using the services and bondman, can come up with $5,000, and that is why we are going to be requesting that monetary amount, Judge.
All right, as to count 1, the court is going to impose $7,500. On count 2, it'll be $1,000. The finding for count 2 is misdemeanor battery and no victim contact until further order of the court. Yoel Marty.
He's approaching, Judge, here, Maine.
Mr. Marty, you are before the court. Count 1 is a traffic capias matter. This is a capias from March 21, 2017 for operating without a valid license. And then count 2 is a civil writ And the court does find probable cause.
Judge, in reference to count one, the operating without a valid license, being Mr. Marty, he wishes to resolve that matter today.
Okay?
And Your Honor, I'm just checking right now. Offered be time served.
Okay?
Judge, he wishes to accept this state's offer.
Okay, Mr. Marty, do you need any more time to speak with the attorney?
No, ma'am.
Okay, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down, sir. Mr. Marty, is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck.
Thank you.
Oscar Quinteros.
He's approaching, Judge.
Okay, Mr. Quinteros, you are before the court. Count one is trespassing, and count two is a municipal ordinance violation, and the court does find probable cause.
Judge, he wishes to resolve this matter today.
Okay?
One moment, Judge.
Sure.
Your Honor, the offer would be adjudication, 5 days county jail. He was just arrested 2 weeks ago for trespassing at this same location. He had another trespass last year that he violated probation on January of this year. He's been to prison for 2 separate robberies of firearm, deadly weapons in his past.
He was on probation for trespassing?
No,
Oh.
he was from a separate trespass.
Oh,
He violated and pled out the VOP January of this year.
okay.
Judge, considering, from what Mr. Lender said, he was previously trespassed at the same location. At this time, Mr. Quinteros wishes to accept the state's offer.
All right. Mr. Quinteros, if you don't want to be in the same situation, you've got to stop going to this place. That's all I can say. So if you wish to resolve the case today, please raise your right hand. All right, sir, do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Mr. Quinteros, is anyone forcing you to resolve your case?
No, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, Mr. Quinteros, what plea do you wish to enter?
No contest.
Sir, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and 5 days in the Broward County Jail. credit for any time served. And sir, I say this every day to different persons with trespassing, you just gotta stop going back to the same place that they keep picking you up, okay?
Good luck, sir.
Yes, yes. Terrence Calloway,
Mr. Calloway's approaching.
Mr. Calloway, you are before the court on a misdemeanor KPS for a petty theft charge. The court does find probable cause,
Judge, you wishes to resolve this matter?
okay?
A documented offer from the state is adjudication, time served, court cost.
Okay.
He wishes to accept the state's offer, Judge.
All right, Mr. Calloway, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Calloway, do you understand everything that's going on here today?
Yes, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am, he's been great.
Are you, oh, that's great. Are you under the influence of drugs or alcohol?
No, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
Sir, do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Then, Mr. Calloway, what plea do you wish to enter?
No contest, ma'am.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck, sir.
Thank you, sir. Mr. Loud? Mr. Loud? Yes.
Amari Loud.
He's here, main judge.
And Mr. Loud, you are before the court for a misdemeanor capious matter on a operating without a valid license charge. The court does find probable cause. What does Mr. Loud wish to do?
He wishes to resolve this matter today, Judge.
Withhold court cost.
All right, the offer is withhold adjudication and court costs, sir.
He wishes to accept the state's offer.
All right, Mr. Loud, if you can raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And Mr. Loud, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case? Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Correct.
And have you ever been treated for mental or emotional illness? And sir, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Correct.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is withhold adjudication and court costs. Good luck, sir.
Good luck, sir.
Mike-
Judge, I've been informed by one of the deputies if we could call a gentleman out of turn right now. He's being requested to be in a different courtroom. And that is Mr. Gilliam on page 20. Good luck, sir.
James Gillen, is that the name?
Yes, Judge, on page 20 of the docket.
Okay, James Gillen. Mr. Gillen, you are before the court. Count one is a misdemeanor KPS matter on a compulsory school attendance violation charge. And then on count two, it's a writ with a hold out of Dade County, which is a no bond hold. So the court does find probable cause. Is he going to court on this charge this morning, or is there something else going on?
No, he's going to a courtroom, Judge. They didn't give him the courtroom
count
number
two.
right now, Judge.
Okay.
He's being trained.
All right, so the bond on count one is $1,000, and he'll be before his division judge. All right, then Michael Humanes.
Mr. Humane, come on up. All right. So,
All right, Mr. Humanes, good morning, sir.
Good morning.
You are before the court for municipal ordinance violation
Yes.
And what do you want to do today, sir?
I want to solve it today.
All right, if you want to resolve your case today, sir, your sentence is going to be adjudication and time served. Is that what you wish to do? Okay, raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Sir, do you need any more time to speak with your attorney?
No.
Have you ever been treated for mental or emotional illness?
No.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And sir, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No. No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you.
Trayvon Sutton.
Mr. Sutton, let me know if when more people hear something.
All right, Mr. Sutton, you are before the court for an ad charge. This is charge number 8 for grand theft auto.
I just want to know when it's.
And so the court does find probable cause.
Judge, in speaking to Mr. Sutton, I believe he has a no bond hold, so nothing to add as far as the monetary bond. We're just curious on this ad charge. When is the alleged date of incident?
This is February 24th, 2019.
Thank you, Judge.
Okay? All right, the bond is $1,000. And then we have Cedric Render.
Mr. Render, come on up, and he declined the service of public defender.
Okay, Mr. Render, you are before the court for a felony capious matter on a possession of cocaine charge. The court does find probable cause. You do have a bond of $1,000, and you will be before your division judge tomorrow at 8:30. Okay? Anthony Lewis. I'm sorry?
Oh, Paul Ryan, Judge.
All right, Mr. Lewis is being reset to the PM. Thank you. Demetrius Flowers.
Conti, Your Honor.
Okay. All right, Mr. Flowers, you are before the court for some additional charges, starting with charge number 3, aggravated assault with a deadly weapon without intent to kill. 4, use or display of a firearm during a felony. 5 is robbery with a firearm. 6 is commit first-degree felony with a weapon. 7, robbery with a firearm. And 8, commit first-degree felony with a weapon. I believe on the second one, it should be an attempt.
Which charge number you're on?
I believe it's 7. It's one of the robberies.
Oh,
I
okay,
think.
let me check.
Let me look at it again. I had that note.
Yeah, I think it's just matching it up with the offense report numbers. I have it as charge 5.
As 5?
Just matching up.
Oh,
the offense
okay.
report
I see
numbers.
what you're saying.
Yeah.
Okay. All right. So on 5, then the court does find probable cause as to 5. It'll be an attempted robbery. Okay. And then I'll hear from the parties as to bond.
Your Honor, I'll start with the easy part first. On counts 4, 6, and 8, just considering the totality of the circumstances, I have no issue with an ROR in those counts. Frankly, I think they'll merge into the charges that are in addition to them on those instances.
Okay.
On count 7, I'm going to be seeking a finding of proof evident or presumption grade for first appearance purposes. Request a no bond hold. On count 3, I'm requesting a $15,000 bond. On count 5, a $50,000 bond in order of no victim contact. Also noting Mr. Flowers is being held no bond on count 1 for robbery firearm. Yeah, but but I think that's going to merge in also.
Judge, in light of the fact that Mr. Flowers is being held no bond on count 1, we would defer any argument regarding proof evident presumption grade until such time as Mr. Flowers can appear in front of his division judge for an Arthur hearing to readdress the bond issues.
All right. Okay, all right, the court does find probable cause, and then, as to 4, 6, counts 4, 6, and 8, the court will ROR Mr. Flowers on those charges. As to count 7, the court will make a preliminary finding of proof evident presumption grade and hold Mr. Flowers no bond on that count, and that is without prejudice for an Arthur hearing.
Judge, do you see a court date for me?
Not yet. I don't have
Alright.
that yet. Okay. And then on count 3, the court will impose $10,000 bond. And then on count 5, it'll be another $10,000 bond. All right, sir. I know, I don't know when your court date is, but I'm sure your attorney will figure that out for you, okay?
Alright.
All right, good luck. Joshua Anglade,
He's at County, Your Honor.
okay.
How you doing, sir?
All right, Mr. Anglade, you are before the court. This is the co-defendant.
Yes, ma'am.
All right, so it'll be the same thing that on count 5?
No, actually, this
Which
one,
one?
the booking was different. This one is count 7.
Okay. So on count 7, then it'll be an attempted robbery. All right, so let me just tell Mr. Anglade what he's before the court. These are additional charges. On 3, it's aggravated assault with a deadly weapon. Count 2 is use display firearm during felony. Count 5 is robbery with a firearm. Count 6 is commit first-degree felony with a weapon. Count 7, I'll make a finding for attempted robbery, and count 8 is commit a first-degree felony with a weapon. And the court does find probable causes to those counts. And this is 7 is an attempt.
I'm just going to be making the same request, Your Honor. No objection to RORs on the firearm enhancement charges. I have no objection to the court setting the same bonds on the ag assault and the attempt. And I'd be seeking a finding of proof evident or presumption grade on charge 5, a no bond hold. Mr. Anglade is being held no bond on count 1 for robbery firearm.
Okay?
In light of the fact that Mr. Anglade is being held no bond on count 1, we would defer any argument regarding proof evident presumption grade until such time as Mr. Anglade can appear in front of his division judge to further address his matters of bond.
Okay. So, Mr. Anglade, as to, we'll do it this way, 4, 6, and 8, ROR. As to count 5, the court will make a preliminary finding of proof evident presumption grade. and hold Mr. Anglade no bond. That is without prejudice for author hearing. And then on count 3 will be $10,000. And then, which one am I missing now? 3.
7.
And then 7. Okay, and then 7 will be $10,000. All right, sir.
Thank you.
All right, Juan Perez.
Mr. Perez is here, Judge, at Maine.
Okay, Mr. Perez, you are before the court for an ad charge of tampering with or fabricating physical evidence. The court does find probable cause.
Judge, speaking of Mr. Perez, he's been in custody, I believe, for about 10 days. He already has a bond. My understanding is about $5,000, and he's still here. He financially can't even afford to post that, let alone an additional $1,000. So I'm asking you to take that into consideration, determining reasonable release conditions for Mr. Perez.
Your Honor, I'm asking that the court keep the bond in place. Part of the reason why his total bond before this is $5,000 is because at the time of his arrest, he was out on pretrial on another case, and Your Honor revoked his pretrial and set a $2,500 bond on that case.
All right, so Mr. Perez's bond on this count is $1,000. Good luck, sir. Alex Dojian Godel.
He's here, present, Judge.
All right, Mr. Godel is before the court for some additional charges, starting with charge number 7, which is petty theft. 8 is fraudulent attempt to use ID of another person without consent. 9 is the same. 10 is a petty theft. 11 is attempt to use ID of another person without consent. 12 is a petty theft, and then 13 is again using the ID of another person without consent. The court does find probable cause.
Judge, he's being held on other matters, so at this time, nothing filed by the defense.
Okay.
Nothing from the state.
All right, then the standard bonds in place will remain. And then Romalise Randell.
He's approaching, Judge. Romales? I'm sorry, Romales. Okay. Romales. Exactly.
All right, Mr. Randell, you are before the court. Charge number 6 is delivering cocaine within 1,000 feet of a place of worship or business. And then 7 is distributing or delivering cocaine. All right, and the court does find probable cause.
Nothing filed by the defense, Judge.
All right. So, finding probable cause, the standard bonds, $7,500, and then $2,500 is in place. Good luck, sir. Robert Pellegrino.
He's approaching, Judge.
Mr. Pellegrino is before the court for additional charges. 2 is a court order that has a no bond hold and not for magistrate. And then 3, 4, 5, and 6 are charges for grand theft. And the court does find probable cause.
Judge, considering there's a no bond hold, nothing filed at this time.
Okay. He does have court tomorrow before his felony judge, and the standard bonds on 3, 4, and 5 will remain. Okay. And then Anthony Fogel.
He's approaching, Judge.
Mr. Fogel is before the court. Count 1 is battery causing bodily harm. Counts 2 and 3 are felony violation of probation, which both have no bond holds. The court does find probable cause, and sir, my notes indicate you have court tomorrow at 8:30 in your felony division. And then the bond on count 1 is $1,000, okay?
Yes, ma'am. Judge, we're gonna just request a photo order.
I'll sign that.
Thank you, Judge.
Aaron Jackson,
He's approaching. Come on, sir.
what is this? Mr. Jackson is before the court for 1 count of robbery with a firearm. The court does find probable cause.
And Your Honor, the state is going to be seeking a no bond hold on Mr. Jackson upon the finding of proof evident or presumption great, noting that he was the participant that was in actual physical possession of the firearm that was used to rob the victim in this case.
We would be objecting to the court making a finding of proof evident presumption great at this time, having reviewed the warrant. I understand the state's argument and how the circumstances between Mr. Jackson and Ms. Dennison differ. However, I would argue that the affidavit does not give rise to the highest standard that we have in the criminal justice system, which is proof evident and presumption great. We don't have any photographs. We don't have any physical evidence at all introduced. Apparently, there was a photo lineup done. The state has decided not to produce that at this hearing. I imagine there were some photographs of the crime scene where these screens were allegedly ripped off. There are no photographs of that presented to the court to verify that that's actually what happened. So our contention is that to establish proof evident presumption great, the state has to establish or present something to the court other than a report written by an officer who did not witness the crime. The witnesses apparently gave statements. Those statements are not produced for the court to review. So the court is basically in the dark as to what actually happened here, yet the state is asking this court to make a ruling on the highest standard of proof that we have. So we'd ask the court to set a bond for Mr. Jackson. The alternative, if the court over our objection finds proof evident presumption great, we would ask the court to exercise its discretion and set bond for Mr. Jackson.
Okay. I have reviewed the probable cause. I do find that there is great concern for the community based on the allegations presented in this affidavit to arrest that has been presented to the court. I am going to make a further preliminary finding of proof evident presumption great, and I am going to hold Mr. Jackson no bond until further order of the court, and that's without prejudice for an author hearing.
And Your Honor, just in abundance of caution, I'd ask for no victim contact, please.
No victim contact and no return to this location. Okay. Devontae Allen,
Mr. Allen is here present, main judge approaching and declining the service of public defender.
Your Honor, it appears this should be a burglary of a structure.
okay. All right, Mr. Allen, you are before the court today. Count 1 is burglar for structure. Count 2 is grand theft. Count 3 is criminal mischief. Count 4 is resisting officer without violence. Count 5 is resisting officer without violence. 6, 7, 8, and 9 are violations of felony probation, which all have a no bond hold. and you will be before your division judge tomorrow at 8:30. The court does find probable cause.
And, Your Honor, the state would be requesting a $10,000 bond, knowing the allegations are, and this was captured on video surveillance, that Mr. Allen used rocks to smash out the front glass window of the business and then stole the cash register from the business, all while on probation for three separate burglaries and an attempted robbery.
Okay, and then as to count one, the court will impose $10,000 bond, and then the remaining bonds will remain. Okay, all right, good luck, sir. Christopher Chen. Okay, Mr. Chen is before the court for count one is possession of MDMA, and count two is felony violation of probation, which has a no bond hold. And Mr. Chen will be before his division judge tomorrow at 8:30. The court does find probable cause. The bond on count one is $1,000. Good luck, sir.
Mr. Jones.
John Jones.
He's approaching, Judge, here at Maine.
Mr. Jones, you are before the court. Count one is possession of a forged driver's license. Count two is displaying or possessing a fictitious ID card. And count three is false ID given to a law enforcement officer. I find probable cause as to those three counts.
Judge, nothing to add from the defense at this time. I'm going to be contacting his friend to post his bond.
Your Honor, I'm going to be asking for a bond increase. I have a concern about his future appearance in court. He has no ties to the community. I can't even advise Your Honor if he has a criminal history, because as law enforcement even noted, they couldn't even verify if this is his true identity.
Oh, okay. So we're not sure if this is John Joseph William Jones?
According to this, he says he was not forthcoming with information regarding his true identity, only that his name was John Joseph William Jones III with a date of birth. Checking numerous databases to identify him came back negative. At this time, it was undetermined as to this to the defendant's true identity. And considering the allegations that he's before the court on using IDs belonging to other people.
All right, at this time, the court does find probable cause. These allegations are that Mr. Jones attempted to look at bank statements allegedly his, but belonging to some other named person. And so the court is going to impose a $5,000 bond on count one. Okay?
Judge, would you consider reducing, from what Mr. Jones is telling me right now, there's no way his friend's going to be able to afford that. Right now, he's not working, he has no money in bank. He's from New York, he's relocated down here. He's been here for 2 weeks. The person that he contacted gave me the phone number, his fiance, and he does not believe she can come up with that. So I'm asking at this time to the court to reconsider and impose the original standard bond of $1,000.
That will be denied. Jerry Parlavecchio.
He's approaching, Judge.
Mr. Parlavecchio is before the court. Count one is burglary, occupied conveyance unarmed. Count two is criminal mischief. And count three is felony violation of probation, which does have a no bond hold. How does it say no bond on the other ones? Is that?
That's just what Judge McCarthy said on the
Okay, I
arrest
see.
warrant.
I see. All right, the court does find probable cause, and I'll hear from the
Judge,
clerks.
considering there's no bond holds, I'm asking for a $1,000 bond on count one, $1,000 bond on count two.
Your Honor, frankly, I was gonna be asking for a $10,000 bond on count one. The reason being, the charges he's on probation for, robbery with a firearm or deadly weapon, armed trafficking cocaine between 200 and 400 grams, conspiracy to traffic cocaine and commit robbery with a firearm or deadly weapon, possession of a firearm by a convicted felon, aggravated assault. He's also been to state prison, and he was sentenced to state prison on that case. This is probation following his prison. He's also been to prison on 2 separate burglaries of dwellings.
Okay. All right, as to counts 1 and 2, the court will impose $5,000 bond on each count. Otis Jones,
Come on up, Mr. Jones.
so Mr. Jones is before the court. Count 1, possession of weapon or ammo by a convicted felon. Count 2, the same charge, possession of weapon or ammo by a convicted felon. And count 3 is possession of cannabis, 20 grams or less. And the court does find probable cause.
Your Honor, I'm going to be requesting a $3,500 bond on 1, a $1,500 bond on 2. He has multiple felony convictions. He's been to state prison. He's been to state prison on 02 and an aggravated assault with a deadly weapon.
Judge, considering the circumstances, that's reasonable. The only thing I'm going to ask, hopefully the state doesn't have objection on count 3, the misdemeanor cannabis, if the court will consider an ROR on that count alone.
I have no objection.
Okay, 3,500 on count 1, 1,500 on count 2, ROR on count 3. Okay. Maureen Auxiliaire,
Mr. Auxiliary, come on up. Judge, he declined the services of public defender.
Good morning, Your Honor.
good morning, Mr. Auxiliaire. Okay, Mr. Auxiliaire, you're before the court. Count 1 is possession of methamphetamine. Count 2 is possession of controlled substance without a prescription. And count 3 is possession of cannabis, 20 grams or less. The court does find probable cause, Mr. Auxiliaire, and I've also been advised that your bond has been posted. So good luck, sir.
All right, thank you, Your Honor.
Okay? Joshua Brokert.
He's approaching, Judge.
All right, sir, you are before the court for a petty theft charge. It says second or, third or subsequent offense. So it's a felony petty theft that you're before the court for, and the court does find probable cause.
Judge, and speaking, Mr. Brocker, he gave me the phone number of a friend who I'm going to be contacting in the court to post his monetary bond.
Okay, his bond is $750. Manny Simmons.
Judge, and speaking, Mr. Brocker, right now, he wishes me to ask the court would consider releasing him ROR.
No, that'll be denied. His bond is $750.
Thank you.
Manny Simmons.
Just happened.
All right, Mr. Simmons is before the court. Count 1 is possession of MDMA, and count 2 is possession of drug paraphernalia. The court does find probable cause.
Judge, and speaking, Mr. Simmons, from what he advised me, no one can post his monetary bond. We're going to be asking for the court to consider releasing him on pretrial release. I'll see if the state has an objection before I proceed.
I'm still looking, but Mr. Romero should probably proceed.
Okay. Judge, he's 47 years old, been here majority of his life, about 40 years. Right now, he advised me he is currently looking for employment. He resides locally in Fort Lauderdale with his mother. His mother is basically assuming almost all the financial responsibility. She's a housekeeper. They do not rent, they do not own, they rent. He does have prior contacts with the criminal justice system, but from what he's advising, it's been about over 2 years. So Judge, considering this is a non-violent offense, that's why we're asking if the court would consider releasing him on pre-trial release with random drug tests.
So the court's aware, I'm showing Mr. Simmons was arrested last year under habeas for a failure to appear in court. Last year, he had a possession of PVP, 2017, possession of PVP, 2013, possession of cocaine, 09, grand theft, 44-month state prison as a habitual offender, 07, possession of cocaine, VOP, same sentence, 04, resisting with violence, 35-month state prison as a habitual offender, delivery of cocaine and possession of cocaine with intent, 2000, 5-year state prison as a habitual offender, escape, 98, 20-month state prison. Prior to that, both drug possession and drug dealing priors.
All right,
Judge, one other thing, before the court makes a decision, my understanding, the reason he needs to be out, Judge, is what he informed me, he has a funeral, he has to be there for this weekend.
Saturday.
This
Saturday.
What's the location?
There's some Pompanos. My uncle's name Clifford Wiggins. You can look it up and find him. He's just been deceased. Clifford Wiggins.
Now, he does have a record. He forgot maybe about that habeas last year, Judge, but I believe the majority of his incarceration, when he spent time in prison, this recent, Judge, that's why we're asking for the court to consider pretrial release. Give him one chance.
well, does Mr. Simmons have a phone number of someone that we can verify that there's a funeral this weekend?
Yes, my mother, Lottie McReed. That's her brother.
And what's the phone number, sir?
954-793-6913.
And what is her name?
Lottie McReed. Pastor McReed also.
You have reached Alpha God Omega Ministry. We are here for the least, the lost, the...
Judge, if you want to, if the court feels more comfortable, maybe we could reset Mr. Simmons for this afternoon. That would give me my lunchtime to try and contact his mother.
Okay. And if you're able to contact her, you need to let her know to expect a call from the court. So I'm gonna need to speak to her.
Yes,
We'll
sir.
reset to the afternoon. James Rubio.
Yes. Mr. Rubio, come on up, please.
All right, Mr. Rubio, you are before the court. Count 1 is possession of controlled substance without prescription. Count 2 is possession of heroin. Count 3 is possession of drug paraphernalia. And count 4 is loitering or prowling, and the court does find probable cause.
Judge, we're going to be requesting that the court consider releasing him on pre-trial release. I'll see if the state has an objection before I proceed.
Your Honor, before I agree, I'd want to hear a little more information about his ties to the community.
Judge, my understanding is Mr. Rubio's been here for 1 year now. He's 43. He is living locally here in Hollywood with a roommate where he's been renting at the same premises for 3 months. His rent is approximately $600 per month. He works, he does pressure cleaning, he gets paid about $14.50. And my understanding is, let me just make sure. Judge, this is his first contact with the criminal justice system.
See, and I was kind of leaning his way until he went there. He's got priors out of Massachusetts. I'm showing him arrested as recently as last year for distributing, possession with intent or distributing Class A drugs.
All right.
Judge, and then ask for a phone order.
I will sign a phone order and the standard bonds are in place. Rodney Franklin. Mr. Franklin is before the court. Count 1 is driving while license suspended. And third or subsequent offense. And count 4 is a traffic infraction not for magistrate. The court does find probable cause.
Judge, hold on a second, let me ask. Judge, Mr. Franklin advised me there's no one that's gonna be able to post his monetary bond. From what he informed me, he's homeless, he gets disability, but no one can afford to post his bond, so that's why we're asking the court to consider releasing him on pretrial release.
Does the state wish to be heard?
I'm fine with pretrial, Your Honor.
Okay, so Mr. Franklin, you'll be released to pretrial supervision. The attorney is going to give you the information. You need to report as soon as you are released. If you do not report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes.
All right, good luck.
Judge, unfortunately, the rest of the gentlemen, I need time to speak to. So if you could go to the other facilities and give me a moment.
Okay.
Thank you, Judge.
All right, North Broward, do we have anyone? No? Nowhere? Oh, that's right. Conti, do you have anyone waiting to be addressed?
Yes, ma'am. Robert Taylor on page 32, 33.
Okay.
And then I have another guy that's out the court.
Who's that? So,
This is Taylor.
Good morning, ma'am.
good morning, Mr. Taylor. You're before the court this morning for aggravated battery causing bodily harm. It is a change of charge.
Yes. Your Honor, Judge Levinson, when he had it, it was an aggravated battery with a deadly weapon, so it's essentially a lateral change of charge.
Okay.
He said a $20,000 bond and no victim contact.
Okay.
I'd ask that the court reimpose the bond.
All right, so Mr. Taylor, you're just brought to the court so that we can let you know it is a technical change. And so your bond, which is originally what, $20,000?
Yes, ma'am.
With no victim contact will remain in place, okay?
Yes, ma'am.
All right, sir.
Okay, and the guy that's out the court is on page 33, Hosley.
Hosley is in court?
He's in courtroom 6870.
All right, so we have to reset Hosley.
Thank you, ma'am.
Thank you, and then that's it, Deputy? No one else at
Yes, ma'am.
Conti? All right, thank
Correct.
you. 20,000 and, is that the change of charge? Yes. And then, Paul Ryan, do we have anyone waiting to be addressed? I don't see anyone sitting there.
Okay.
Okay. All right, so then, we'll be in a brief recess until Mr. Romero is ready.